Ms. Clark, how many witnesses do you have for this hearing?
Your Honor, the state says one witness, which will be Lieutenant Gas.
Excellent. All right. So we're not waiting on anyone. You're ready to roll once Mr. Slaughter figures out how to join us.
Yes, Your Honor. We're all set.
All right. Why don't we do our other hearing while Mr. Slaughter figures out what to do, and you can reach out to him, ma'am, to encourage him to make this work. Ms. Wood, good morning.
Hello, Judge. How are you?
I am all right. Your client is on, and we'll get you on. Mr. Farmer, I need you to turn your video on or make it not look like a black square. All right. Here we go. So we're going to go on the record, Ms. Rivers, in 23 SC 189119, State versus Tyron Farmer. Mr. Farmer is charged with aggravated assault, possession of a firearm by a convicted felon, and possession of a firearm during commission of a felony. And his lawyer, Ms. Wood, has moved to modify Mr. Farmer's bond. And I think specifically it is to remove the ankle monitor while every other condition would remain in place. Mr. Farmer, you are where right now? I don't need a street address. I need a city.
New York.
All right. As in the city of New York?
Yeah, New York, New York.
Okay. Do you waive your right to be here in court today?
Yes, sir.
All right. Your lawyer is not in New York, New York. She is in Atlanta, Georgia. You have a right to have her by your side so you can consult. You can still consult privately with her by calling her and she could talk to you. Do you waive your right to have Ms. Wood by your side up there in New York, New York?
No.
You don't? We should stop the proceeding and she should go up to New York to be by your side?
Yeah. Yes, yes, yes.
You're okay having her in Atlanta while you're in New York?
Yes, sir. Yes, sir. Yes, sir.
Okay. If you need to speak with her privately, will you let me know?
Yes, sir.
Okay. Ms. Clark, are you ready to go?
Yes, Your Honor. State, sir.
Okay. Ms. Wood, I think I summarized it. You want Mr. Farmer to have the county-funded ankle monitor come off. He's been on bond for by now it's maybe 300 days. So why don't you share with me why you think the ankle monitor should come off, and then I'll hear from Ms. Clark. I know Ms. Clark has shared with you a bunch of photos that she wants to share. We can talk about, we can admit whatever we need to admit. I'm focused mostly on making sure the alleged victim is safe and that Mr. Farmer complies with the conditions of bond. And he's up in New York, New York. So tell me your thoughts.
Thank you, Judge. And before I get into my motion, I did receive that email this morning. I'm not planning to get into any facts of this case. I don't think they're relevant as it is a bond modification hearing. So if the state is planning to admit any of those photos, I will be objecting. Mr. Farmer is 29 years old, Judge. He has been out on bond since September 28, 2022. He posted a $95,000 good bond. It is my understanding that he's been compliant with all conditions for over a year now. I did not see any history of failures to appear in the pretrial report. It is a county-funded ankle monitor. We are asking for it to be removed completely. He's currently unemployed, so I don't think if the court were to switch it over to him paying for it, I don't think that would work either. He did serve 254 days on this case before making the bond. Judge, as he's in New York, that's where he lives. He doesn't have any issue with maintaining the condition of no contact with the victim in this case. And Judge, the last thing I want to point out is he had a private attorney that withdrew. And so he actually came down from New York for his plea arraignment without representation. So I'm confident that he will come to court when he's needed back in court, Judge. So we're just asking the court to consider taking off the ankle monitor condition of the bond.
All right, I'm just looking at the bond. So it was reduced from 100,000 to 95,000. He was able to make that. It's got all sorts of conditions. Okay.
Yes, I have my name on it already.
Okay, all right, I'm gonna go back in there then. See you in a little.
All right, that would be Mr. Slaughter. Better late than never. Okay, Ms. Clark, what I'm hearing Ms. Wood say is that the sole condition that she wants to modify is the county-funded ankle monitor part. I'll let you know that we are, the courts are now looking real carefully at why we would have someone on a county-funded ankle monitor for more than 6 months. This is well past that. So we'll need to work through the wisdom and the merit of the county spending all that money for these additional days past 6 months, if in fact Mr. Farmer's been compliant. Ms. Jackson, good morning. I've got a couple questions for you before I hear from Ms. Clark.
Yes, Your Honor. Good morning.
Good morning. 2 questions. One, does your review of Mr. Farmer's criminal history reveal any history of failures to appear?
No, Your Honor.
Okay. And then I don't know if you have access to this. You and I haven't had a conversation like I'm about to ask you about. And that would be whether there's anything in not criminal history, but in pretrial services records to suggest that Mr. Farmer has had any problem complying with, if he is on pretrial supervision, if he's had any problem. Well, he wouldn't be, because he's not subject to pretrial supervision because he has a private bond. So never mind.
Okay.
All right. Thank you. Ms. Clark, your thoughts, please.
The state is opposed to a bond being modified in this case. The defendant is, when you're looking at the Ayala factors, is a risk, a high risk. But first of all, Your Honor, there is no material change in circumstances. The state understands that the court's concerned about county-funded ankle monitors. However, in this case, based on the nature of the case, it is the state's opinion that either if the county doesn't fund it, then the defendant should fund it, because in this particular situation, based on the violent nature of the crime and the circumstances related to the case, that an ankle monitor is appropriate. I wanted to point out for the court, Your Honor, that the defendant has had a failure to appear June 14th of 2021 in his unindicted case 21 CP 200-647. So he actually does. Also, Your Honor, I wanted to point out that the defendant was on bond for another case in Fulton County, 19 SC 168497. The incident date for that was May 3rd, 2019. So when for that offense, so he actually was on bond for an offense in Fulton County when he committed this offense, Your Honor. So we feel that the
Has the 19 SC case been resolved or is it still open?
That case, Your Honor, is still open. Also want to point out the fact that when the defendant committed these actions, he was on parole in the state of New York for his as part of his sentence in his conviction. Give me a moment, Your Honor. So he has for his three different convictions on grand larceny in the 4th degree in New York. So he was on parole in another jurisdiction when he committed these offenses. Also, Your Honor, the state would like to point out the fact that when you're looking at the defendant has no community ties. Defense counsel has not discussed any of that. And we want to point out, Your Honor, that under 19 SC 168497, the defendant has been charged with false ID. So the likelihood of committing offenses while out on bond, it is the state's position that him having an ankle monitor is likely the reason why he may not have contacted the victim in this case. The heinous nature of this case, I know that I submitted the photographs to the court as well as opposing counsel has received those. But I just wanted to, I know that opposing counsel did say that the facts of the case are not at issue in this case, Your Honor. But I think that when you look at the fact that there is surveillance footage that shows that our victim was in a car at a gas station and the defendant was in a car that blocked the victim and her friends on one side, on the rear side of the vehicle. And then there was another car that was a 2020 Toyota Highlander that blocked the victims from driving forward. This was a calculated, planned attack.
Case where Mr. Farmer got shot also?
Yes, Your Honor.
Okay, so Ms. Collier got shot
Yes,
and Mr. Farmer got shot.
yes.
And is it the state's theory that Ms. Collier shot Mr. Farmer or some third party shot Mr. Farmer or Mr. Farmer shot himself?
No, Your Honor. It is the state's theory that based on the fact that that there was shooting coming from the defendants or the unknown defendants in the Toyota Highlander, and those individuals were shooting forward. Mr. Farmer, if you're seeing on the video footage, is seen where he's pointing on the same side, the passenger side, where the victim was shot in this case. So it is very likely, we can't say because
Were there other people in Ms. Collier's car?
yes, there were other people in the car. So there were two people on the, they were in a Mercedes SUV. So there were there were some individuals on the front seats and then a middle seat in the back seat. And the victim was shot. On the actual surveillance footage, we have surveillance footage of the actual Mercedes truck that the victim was in. You see that there were bullet holes that came through the front windshield. Also, there are bullet holes that came through the side. So in the crossfire and the heinous nature of this case, the facts are very relevant. Also, the fact that the victim is here and would like to make a statement through the victim witness advocate, and her family is here. She is terrified, not able to even go to a gas station. Her family reports that she is traumatized when she hears anything, a pop or anything, and she has significant damage to her face, her ears. She has bullet fragments that are actually in the top of her eye that have not been removed because it has been indicated that that could possibly cause brain injury or other harm or other harms that are even further. So based on this, the fact that the defendant has had a failure to appear, again, 6/14/2021, and the fact that he, in terms of the Ayala factors, poses a high risk of reoffending in this case. And we believe that him not having an ankle monitor, there's a strong possibility that he may use that as a means to intimidate the victim in this case. And because of the fact that the defendant, there are other co-conspirators that were involved that the defendant has not named in this case. And Your Honor, I'm not saying that he's obligated, but what I'm saying is that there are other offenders. It is a likelihood that there is even more intimidation because the state is still trying to ascertain other co-conspirators in this case. But we do know that Mr. Farmer is, in fact, his bond should not be modified. And there is really no material change in circumstances that that defense counsel has shown, which is the test that is required. As opposing counsel indicated, the defendant is unemployed.
Okay, you shared a lot. I have a question for you. I need to get something on the record, and then I want to hear a little bit from Ms. Wood. And then I certainly need to hear the impact statement from Ms. Collier. Is it Ms. Collier's position that Mr. Farmer was someone she knew or is a stranger to her?
A stranger to her.
A stranger, okay. This FTA you're talking about, I'm having a little trouble following because the 21 CP you mentioned, which your office has declined to prosecute, so that's closed out. Mr. Farmer didn't get arrested on that until 6/15. So I don't know how he missed court the day before. He got locked up on the 15th of June, 2021. It's not going to move the needle much, but I don't want you to carry around bad information because I don't think legally or actually factually he could have a failure to appear the day before he was arrested on something. Ms. Wood, tell me why it is burdensome to Mr. Farmer to have this ankle monitor on. I looked at the calendar. We've got a final plea date in early January, less than a month away, and a trial date soon after that. And so I'm a little reluctant to change things up with so little time between now and Mr. Farmer having his day in court. What is the burden that this ankle monitor that is free of charge for him?
Well, Judge, I'll answer your question, then I do want to add something else. It's burdensome because number one, he has to keep it charged. He has to walk around with an ankle monitor on. I know in the past for many clients, it's been an issue for them to get gainful employment when employers find out there is electronic surveillance on their bodies. So that would be my answer to that question, Judge. And I do want to share with the court in full candor, Mr. Farmer actually was interested in seeing if we could resolve this case today. However, we did not receive discovery until Thursday afternoon and Friday afternoon. Discovery was due in this case November the 2nd. At this time, I still don't have an offer, and I am unable to speak to those videos that Ms. Clark spoke of because it's at least 24 videos that were given to me on Thursday. So I think I was very generous in letting her go on about the facts of this case. And Judge, at this time, we understand if the court feels the need to leave the ankle monitor in place, we'll continue with the resolution.
Okay, thank you for sharing that. Ms. Clark, why would discovery have been provided to Ms. I guess there was a change in counsel, but that was a while ago. Ms. Mormon, I think, was on the case for Mr. Farmer, but she rolled off. Any reason why you're telling me about videos that you provided to Ms. Wood only a few days ago?
Your Honor, the state did serve discovery in this case. When I came onto the case, Ms. Wood notified me on Friday morning that she did not have the link. And in my search of in the search of the system, since she couldn't find the link, and then because of the fact that there was a change in counsel, I decided to have it reserved to her.
Okay. Do you know, Ms. Clark, if there are parts of the discovery that might yield a motion to suppress if Mr. Farmer was interviewed by the police or anything like that? I mean, videos generally aren't suppressible if it's just surveillance video. But was there, it sounds like for Ms. Collier, Mr. Farmer was a stranger. So I don't know if there was an identification that Ms. Wood might seek to suppress, or if there were statements that the police obtained from Mr. Farmer. And I'm asking only because I've described a pretty tight timeline of final plea coming up in a few weeks and then a trial calendar, but all that'll be thrown off if Ms. Wood learns from the discovery she only just received that there are items that are subject to suppression. And you may not know offhand, I'm not asking you to give a binding answer, but
Yeah.
you might know, oh yeah, he actually gave a 4-hour statement to the police.
Your Honor, so based on my review of the discovery in this case, there are no statements that the defendant has provided that would be subject to a Jackson Deno, and there are no identifications that are at issue in this case because, as you pointed out, the defendant was shot on scene.
Okay.
So, and the victim did not know the defendant. But in this particular case, based on the fact that there was a different attorney on this case, I don't want to speak. He did retain an attorney. I'm certain that discovery was served previously, but I know that I had it served when I came on.
Okay.
And when it was brought to my attention on Friday that that Ms. Wood did not have it, I made sure that my legal assistant served her at that point.
Okay, and that may have been what prompted Ms. Moorman to withdraw, is that you sent discovery and she thought, dang, I was on this case a while ago and it was to get bond for Mr. Farmer and that's it. I just want to make sure that Ms. Wood has enough time to get up to speed with the discovery. So two things. I'm not going to remove the ankle monitor at this point. Because of that, I don't need to hear the victim impact statement. I'm happy to do that, but I want to minimize the impact on Ms. Collier, and just hearing that statement could be difficult. I'm happy to hear it if she wants me to hear it now. There'll be several other junctures at which time that could happen. If there's a plea, if there's a trial and Mr. Farmer's found guilty. So I don't want to deprive her of that opportunity, but because I'm not going to be granting the relief that's being sought, it doesn't strike me as necessary, but I don't want to get sideways with old Marcy's Act. If she wants me to hear it, then I'll do that. So it looks like, was that a victim advocate who just went outside?
Yes.
So she can speak with Ms. Collier. Ms. Wood and Mr. Farmer, I'm not forgetting this request. If for any reason not caused by the defense, we cannot move forward with the final plea hearing and then the trial date, then I'd ask you to renew this motion. But if we stay on schedule for a final plea in early January and then a trial soon thereafter, or a non-trial resolution, you guys are going to do what you do. I'm going to leave things as they are. But if there's more discovery that you didn't get, or the state can't be ready for something, or you get an offer 20 minutes before final plea, then we should revisit this. But between now and then, it's just a few weeks. I'm going to maintain the status quo. Okay, all right. So we'll not hear from Ms. Collier because I'm maintaining the status quo. Ms. Wood, do you have anything else you want to get on the record on behalf of Mr. Farmer?
Not at this time, Judge.
Okay, please let me know through Ms. Nelson if there are any issues with the discovery you got. Obviously, work with Ms. Clark first, and hopefully the two of you can sort that out. But if you can't, I don't want Mr. Farmer's case to be delayed in any way that I can impact. If it's something larger than that, or you find there's a motion that needs to be argued, certainly let Ms. Nelson know and we'll go from there. Okay?
Thank you, Judge.
All right, Mr. Farmer, you are free to go.
Your Honor, before
Everyone goes, hold on. Yes.
Because I just wanted, so that the record is clear, PD Wood indicated that the state had not made an offer. I'm sure PD Wood can confirm that I did, the state did ask would the defendant be interested in making a proffer against his co-conspirators?
Okay,
And
I don't know, you
yeah.
want to get that on the record? You may want to leave
But I
that
just wanted
off the
to,
record.
yeah, I just wanted to,
Okay.
yeah.
I understand. I
Yeah.
understand you two have been communicating. I
Right.
appreciate Ms. Wood sharing what she did. I know she is generally open to resolving cases, and I want to make sure folks are engaging her when she reaches out to say, hey, let's see if we can resolve a case. We've done what we need to for today. Mr. Farmer is free to go back to New York, and he will need to be here in person when we have our final plea. But that's not until next year. All right. Thank you, Ms. Wood.
Thank you, Judge.
All right. Mr. Slaughter is on, and we will put him on the spotlight. There he is. Let's pivot to the suppression hearing. Ms. Rivers, you ready to switch gears?
Ready.
Okay. And Ms. Jackson and Ms. Tucson, you all are free to go for now. We're going to do a suppression hearing, and I don't think we'll need anything from either probation or pretrial supervision or pretrial services, but thank you for plugging in. We'll see you at our afternoon calendar.
Yes, Your Honor.
Okay, thank you.
You bet. All right. So this is 23 SC 189-135, State versus Slaughter. Mr. Slaughter is in Arkansas. His lawyer is here in court. Ms. Clark, the prosecutor, is here in court. Mr. Slaughter, can you hear us?
Yes, sir.
Do you waive your right to be here in court? And are you comfortable proceeding virtually?
Yes, sir.
Do you waive your right to have your lawyer by your side, but instead have her here in court?
Yes, sir.
Okay. If you need to speak with her in private, will you let me know?
Yes, sir.
All right, we're going to move forward. I have a motion to suppress that is premised on what is alleged to have been an unlawful stop. And then beyond that, it was an arrest for which there was no probable cause, and also the improper administration of the implied consent admonition. I don't want to miss anything. Does that sort of cover it?
Yes.
Okay. So the state knows what it needs to prove up. When you're ready, Ms. Clark, you can call your first witness.
Your Honor, before the state calls this witness, the state would like to ask, just so that our questioning can be in line, to ask the defendant to make a more specific proffer. How was the stop unlawful? Even though that statement is made, there's no particular indication of why it was unlawful, and how was the implied consent not administered properly?
So for the stop, there is a claim that the arresting officer did not have reasonable articulable suspicion to conduct the stop. I think that's a sufficient articulation. Your officer is going to say, here's what I saw. His tail light was off.
Okay.
That's enough if the tail light wasn't working. I don't know the facts at all, but if your officer establishes that Mr. Slaughter was speeding, he didn't signal, you know, it doesn't take much to justify a traffic stop. I don't know what the basis was, but there is practically an infinite number of sufficient bases. I don't know much about implied consent stuff because that's usually in state court. Was there a particular defect in what I would love to avoid? I've had a couple cases because someone ended up dying in connection with a DUI where we have to duke it out over the implied consent, or it went so far as when they got blood at a hospital. And it was helpful to me to know in advance, yeah, the issue was X. What is your concern about the implied consent?
Well, Your Honor, it's kind of twofold. First of all, I don't have a video, any sort of recording of implied consent being read to Mr. Slaughter. I have body-worn camera that you sent over to me, and I believe based on when it was read, I think it was read to him later at the hospital. And for whatever reason, the body-worn camera was just not on at that time. So there's no way for me to know If it was read properly,
Got
if
it.
Mr. Slaughter responded in a way that warranted some sort of,
Okay,
different,
so it may have been to the letter of the law, you don't know. And so being a zealous advocate, you're saying, I don't even know implied consent was good because I don't have any evidence of how it happened.
yes, and it needs to be shown that it was.
Yeah, no, I'm not disagreeing as to who has the
As well as
burden.
the timing of when it was read.
Okay, we'll work our way through it. When you're ready.
Your Honor, in this case of State versus J. Slaughter, the state calls Lieutenant Gas to the stand.
All right, sir.
So I thought that testimony will be the whole truth.
Yes, sir, I do.
Today's name, first.
I'm Lieutenant Logan Gass, first name Logan, last name Gass.
2 S's?
Yes, sir.
Thank you.
What is your occupation?
I'm a lieutenant with the Georgia State Patrol.
And and how long have you been employed with the Georgia State Patrol?
Since May of 2010.
Were you working on the date of December 30th of 2021?
I was.
What were your duties on that evening of the date of the arrest?
At that time, I was the post commander over the DUI task force.
Is that statewide or within, as a post, a
Yes, sir.
geographical?
Over the Nighthawks North, which covers the metro Atlanta area.
And so you were the commander of Nighthawks North.
Yes, sir.
And could you tell the court your previous law enforcement experience?
All of my experience has been with the Georgia State Patrol. I graduated trooper school in November of 2010. I worked approximately over 4 years in North Georgia in the Catoosa, Whitfield County areas. From there, I was promoted and worked 2 years in Rome, Georgia. Promoted again, worked about a year and a half, a little less than a year and a half in Marietta in North Atlanta. Promoted again, went back to Rome for a little less than a year and a half. And then I transferred to the Nighthawks DUI task force in October of 2020.
And approximately, do you know how many DUI traffic stops that you have done since that time?
DUI arrests somewhere between 800 and 900, around 850. I don't know the exact number.
And are you post certified?
I am.
Do you have any training in the detection of impaired drivers?
Yes, ma'am.
Could you explain?
We go through standardized field sobriety in trooper school and DUI detection. It's the standard class that all troopers are trained on during trooper school and learning how to administer the field sobriety test. The last 3 months of trooper school are field training with 3 different troopers, different posts in the state. So you have hands-on experience patrolling for and administering the field sobriety test under the watch of another trooper, or also watching them give the field sobriety test. After trooper school, I went through ARIDE, Advanced Roadside Impaired Driving Enforcement. And then I have been through the Drug Recognition Expert program as well. And then various other just field sobriety updates along the way.
And you indicated that you were on shift December 30th of 2021. Do you remember specifically when you were on shift?
Our shift at the time was 8 p.m. to 6 a.m.
And the traffic stop at issue, do you know the vicinity or the location?
Yes, ma'am. I don't know exactly. I had several spots where I would sit and monitor traffic along Peachtree Road. I don't remember which one I was in specifically, but it was somewhere along Peachtree and around St. Philip's Cathedral, somewhere in that area. Would have been the first time that I saw the vehicle.
Is that the big curve on Peachtree?
Yes,
And that is in Fulton County?
it is.
Were you alone, for this arrest?
Yes, ma'am. There was other troopers patrolling in the area and some that arrived to assist afterwards, but the main incident itself, I was alone for.
And were you in uniform?
I wasn't.
Are you ever not in uniform?
Very, very rarely.
And were you, at this time, were you on foot?
Oh, man. I was sitting in a patrol car.
And were you on patrol?
I was.
And as a part of this investigation, did you do a report?
I did.
And did what typically, or do you recall when you actually did the report?
Likely the day after. I don't remember the exact time that it was completed. It could have been later that night. I don't remember, to be honest with you.
Your Honor, may I approach the witness?
You may. Both of you lawyers are free to approach the witness.
Let the record reflect that I'm showing opposing counsel the document that I just handed. Your Honor, I'd like to mark the statements, identify statements one, for identification purposes only. And Lieutenant Gass, if you will, if you could take a moment to look at the document that I handed you. And you can let me know, okay, could you state what that document is?
It's the DPS incident report we complete for all arrests and certain other incidents.
Is it the equivalent of like a police report from whatever, but it's just the form that GSP uses?
Yes, that's correct.
And these are done for every investigation?
Mostly, yes. There, we have crash reports for crashes that we investigate, but most arrests are covered under this type of incident report.
And if the document that I handed you, you reviewed all of the pages?
Yes, ma'am.
Okay. And from that copy that I handed you, do you see if there were any additions or deletions from the report that you provided?
No, ma'am, not that I see.
And does it fairly and accurately depict the report that you completed for this investigation?
Yes, ma'am.
Your Honor, at this time, the state moves to enter this document as the State's Exhibit 1.
Any objection to the admission of States 1 for the purposes of this hearing?
No objection.
It's admitted. So I'm going to cut to the chase a little bit. I didn't know anything about the case. I just skimmed this report, and I don't in any way want to curtail your pursuit of Mr. Slaughter's rights. If the facts are 1/10 as alarming as what's in the report, the probable cause for the stop, he actually didn't stop the car. Your client crashed the car and ran on foot. I can get those words out of the lieutenant's mouth, but I think maybe implied consent is where we ought to leapfrog. I'm not asking you to waive anything. We can make a record, but this is not like a preliminary hearing. I'm not a big fan of, I want to lock an officer into his testimony before trial. Your client was speeding, it sounds like, was crossing double yellow lines, and regardless, crashed his car into a utility pole and ran from the car. Didn't stop there, allegedly. I'm going to ask Ms. Clark to speed it up a little bit, no pun intended, to get to that part. But this doesn't seem like a case where you're going to get traction on the validity of this, or the invalidity of the stop or the arrest. I can't speak to the implied consent. That could have been totally botched, and I want us to focus on that with greater attention. Are you comfortable if we just kind of quickly work through did he really go that fast down Collier and we even crash? and just establish those basics, and then we could jump to implied consent?
Yes.
Okay, so let's do that. Why don't you tell us what you saw that night, and don't read from your report. If you need to refresh your recollection by looking at it, that's okay. But I need you, from having your recollection refreshed, describe to me what this, was it a Charger or a Challenger? What the Challenger was doing, how it came to a stop, and then it sounds like maybe there was a little foot chase and a gun too.
Yes, sir. So I observed the Challenger traveling south on Peachtree at a high rate of speed. That's the first thing that drew my attention. So I got behind it. I observed that he was unable to maintain his lane, and that he made several lane changes without the use of a turn signal.
Were you able to determine the speed because you had a radar gun, or because when you got behind him, you had to go 50 to keep up with him on a street that has a speed limit of
I
35?
had a radar installed in the patrol car at the time, so I checked his speed at 59 miles an hour and 35 mile an hour.
Okay,
On the video as well, there, some of the failure to maintain lane and failure to signal lane changes prior to the video coming on. I actually activated it myself once I got behind the car. So you can see that a couple of times on the video.
okay.
As well as his speed is evident as well.
So he's southbound on Peachtree and then eventually turns where?
He was, when I turned the blue lights on, he was making a right turn on the Collier Road.
Okay,
Turned the blue lights on, there was a little bit of hesitation, and then he immediately accelerated, turned the siren on, and he fled. The roadways were wet, so I was extremely cautious. I knew Collier, the winding, curving road.
these aren't strange streets to you. You're familiar with these streets?
Yes, sir.
Okay,
But I kept him in sight till he was passing traffic on a double yellow line.
when you say he's passing traffic, Collier in some places has 2 lanes on one side. The direction he was going was only 1 lane.
Yes, sir, I believe so.
So if
One
he's,
lane each direction.
okay, well, by the hospital, it's 2 lanes at least if you're going towards Peachtree.
Right.
But when you get away from the hospital,
But this was across a double yellow line. It
Okay.
looked like he was passing within.
that's all I was getting at, that he wasn't passing by going into another parallel lane of traffic. It was crossing the double yellow.
Sir, he was accelerating to the extent where when he would get on the accelerator, the back end will begin to break loose till the traction control caught it. Did that a couple of times. Eventually, he made it through the big sweeping curve where the overpass is, lost control, ran off the road, hit a utility pole, and then the car came back into the road, came to rest, and he got out and ran on foot. I pursued him on foot. As he was running, he threw a gun into the creek that flows under the overpass there, or the bridge. The foot pursuit didn't last much longer than just the other side of the overpass. He stopped, got on the ground, complied. So I placed him in handcuffs. He also had another firearm. Let's see exactly what it was. The one he threw was a Glock Model 19 that we found later in the creek. The one on his person.
So there were 2 guns, one that was tossed and one that was still on him.
Yes, sir. The one that was on him in his pocket was an M&P 380.
Okay.
So I brought him back to the car, placed him in the back of the patrol car. There was a female that was in the passenger seat at the time of the crash.
He ran from a car, leaving a passenger in the car.
Yes, sir. When I went to chase after him, when I saw him get out of the car, there was a transformer that blew as well, kind of threw me off. I left my car and drive. So it slowly rolled forward and hit his car.
Who gave you a ticket?
Yeah, exactly. Nobody. So she was able to get out of the car before there was any contact made. It was minor there, but I say that to say that when I got back, I placed him in the back of the car, began checking on her, trying to get the scene secure. So implied consent wasn't read immediately at that time. During that time, we had an ambulance in the way. He began throwing up in the backseat of my patrol car repeatedly. So when the ambulance made it there, they took care of him, checking on him. They transported him to the hospital. I had a trooper accompany him to Grady Memorial.
Does that mean the trooper rode in the ambulance with him?
He followed him there. And then once he was at the hospital, he sat with him until I could get the scene cleared. Then I went there, and then I made contact with him again. I had other observations along the way. His eyes were watering, bloodshot, speech was slurred. He made a statement in the back of my patrol car that.
So we should slow way down now. All these things you're describing occurred after you had secured him, brought him back to your patrol car, and then it sounds like there were a variety of observations you made, to include that he was sick. I'm gonna let Ms. Clark ask what she wants about that, and obviously Mr. Slaughter's counsel can ask you about it as well. I just wanted to, having glanced at your report, I didn't think we needed to go turn by turn with what led to not you stopping the car, but actually Mr. Slaughter crashing the car and then getting out and running from it. Okay. Back to you, Ms. Clark.
So you indicated, after the crash, what did you observe about the defendant?
His eyes were watery and bloodshot. His speech was slurred. He had the strong odor of alcohol on his person and on his breath. He was, I'd say, belligerent. Just he was trying to get to her, screaming for her, the passenger, pulling away from me as I brought him back to the patrol car, and was very reluctant to have a seat in the back like I needed him to. I checked on her. Like I said, we were trying to get other troopers on the way to the scene, get EMS on the way to the scene, and he began vomiting in the back of my patrol car repeatedly.
And based on your training and experience, what did you believe, or what was your reasonable suspicion at that time as it relates to the defendant?
Not only that he was impaired to the extent that it was less safe for him to drive, but that he appeared drunk.
And the defendant, how was the defendant transported to the hospital?
I believe he rode in the ambulance with the EMTs.
Which hospital did he go to, did you say?
Grady.
Grady?
Yes.
And what did you do? So the defendant was transported to Grady. What did you do next?
After they left the scene and things had calmed down, I stopped the video and went back and watched the video again. You can see him throw what turned out to be the firearm into the creek below. So we spent a period of time. I don't recall exactly, 3 or 4 troopers there, and one of my troopers on the unit found the firearm. It was sitting below the surface of the water, but you could stand on top of the bridge and see it. It was maybe a foot or so below the water line. You shine on it a flashlight, clearly see it laying there on the rock.
And the gun was retrieved. Okay. And then what did you do next?
After we cleared the scene, I went to Grady Hospital to speak with, or well, to make contact again with Mr. Slaughter.
And what did you do when you came in contact with the defendant at Grady Hospital?
Before we get there, you had started to say something. This is when I got out of the way and said, let's take it in smaller bites now, that Mr. Slaughter either said something to you when he was in the back of your car, or you asked him something. There was some verbal interaction you all had other than him throwing up. Tell me about that.
While he was in the back of my patrol car, I was trying to figure out who he was, checking through GCIC to find if he had a valid license, or just identify him in general. So I was asking him questions about his name, date of birth, specific to that, and he was having a hard time answering the questions. And he told me that he couldn't think right then because he was heavily intoxicated.
Those were his words?
Yes, sir.
Did he say the phrase heavily intoxicated? Okay.
Okay, so moving back to being at the hospital, you coming in contact with the defendant, what did you do at that time?
I read him the implied consent notice for suspects age 21 and over.
And why did you do that?
Based on all my observations, the driving mannerisms, the less safe driving mannerisms that I described earlier, his physical manifestations as well, the watery bloodshot eyes, slurred speech, and odor of alcohol on his breath.
And you indicated that also when you turned your sirens on behind the defendant, you indicated the rate of speed. What would that be an indication of?
I mean, he was well above the posted speed limit. I don't know his exact speed. I know EMTs asked me on scene how fast he was going when he struck the pole, and I estimated 50 to 60 miles an hour. I didn't check him on radar while he was running. I was focused on driving, but I would say he got in excess of 60 miles an hour on Collier Road.
So was that also factored into why you decided to read the implied consent?
A small part. The driving manifestations that I saw prior to him fleeing were factored into that. That was the reason for the stop. Like I said, I was on the DUI task force. My experience with dealing with impaired drivers, you see a lot of those types of things. So that was the reason for the stop. His physical manifestations going along with that was consistent with somebody that was driving impaired.
And and you did not read the implied consent on scene?
No, ma'am.
When you read it at that time, was that the available time that you were able to read it, or?
Yes, ma'am. Like I said, there was other concerns at the time that were more important than reading it on scene. Was to get him medical care and get him to the hospital and get everything cleared up. So that's why I waited until I did to read the implied consent notice.
And what happened after you read the implied consent?
He refused consent for the test. So the blood test was not administered, and he was cleared by the medical staff at Grady, and then he was transported to Fulton County Jail.
And the transport was conducted by you?
Yes, ma'am.
And what did you do after he was transported to Fulton County Jail?
He was turned over to the booking officers when I got on the EWI warrant system and completed the application for the warrant, spoke with the judge, and the warrants were signed.
Your Honor, no further questions for the
Christina.
excuse me, 1 second, Your Honor.
Okay.
And your Lieutenant Gas, do you recall, were you able to identify the defendant are you able to identify the defendant in this courtroom or virtually?
Yes, ma'am. He was on the video that's up there still.
Your screen may have, you can make that thing go away.
I can see it when I was sitting up here, and I can see him here now.
Okay, but just for,
Okay,
since
I'm
you're gonna
sorry.
keep that, click the stay muted button. Oh, that's it. There you go.
All right, Your Honor, nothing further, thank you.
When you read implied consent, is that something that you've committed to memory? Is there a form you read?
No, sir. I've got a card.
Sort of like officers have the Miranda rights. You've got you may have that as well, but you've got an implied consent card.
Yes.
Okay.
Ooh, you want to get a new one.
Yes, sir.
Okay. And if someone refuses implied consent, then that means you don't draw blood or have them blow on a breathalyzer or whatever.
Yes, correct.
Okay. 1 second. Okay, you're up.
Good afternoon.
Good afternoon.
So just to make a few things clear, I'm not gonna drag you through all the details again, but you're on Peachtree Road, correct?
Excuse me.
Hold on 1 second. Can you turn that microphone, if you put your finger in there's a little indentation. There you go, and take your finger out. Did it turn green?
Yes.
There we go. Now they can hear you.
Okay. This was on December 30th, 2021, correct? So almost 2 years ago, right?
Correct.
And you're on Peachtree Road.
Was it?
And you see a Challenger and you clock with your radar that he's speeding.
I observed him speeding first, started catching up with the vehicle, and then checked into the radar.
Okay. And once you lit up the blue lights, that is when you allege that he fled and eluded,
Yes, ma'am.
or that he fled from you, correct? And you followed after him, and all of the things happened that ended with him no longer being in his car and you having sort of control of this scene, correct?
Yes, ma'am.
Okay. And again, Mr. Slaughter's car had hit a utility pole, right?
It did.
There was an explosion.
Yes, ma'am. One of the transformers did.
He had a passenger in his seat as well.
He did.
And once you secured Mr. Slaughter, you also spent a little time talking to the passenger, making sure she was okay, correct?
Did.
Right, because she had just gone into an accident, right?
Yes, ma'am.
And I know you mentioned that you believed that he was drunk based on slurred speech, right?
Yes, ma'am. A number of things, not that alone.
Watery, bloodshot eyes, and the fact that he was throwing up in the back of your patrol car.
Those are all part of it. Yes, ma'am. Not
Correct.
based on any one of those things.
And at the time that he was throwing up, again, you don't know whether or not he was throwing up because he was drunk or if he had some sort of physical response to having just gotten into a pretty serious car accident.
With all the things that I had to make a decision off of, that I could see that it was based off the fact that he was drinking heavily, was drunk. Like I said, he was cleared at Grady Medical Center, so they didn't have any indication that he had any kind of head trauma or anything that might have caused it.
Right, but you didn't know that he was cleared yet at the time that you were taking these things in, right?
Correct.
Right. And, even Mr. Slaughter having said, I'm intoxicated, right? He said that to you, correct?
He was, yes, ma'am, heavily intoxicated.
Heavily intoxicated, but you don't know whether or not he was referring to alcohol, correct?
That was my understanding.
Well-
I don't know what else he would have been referring to.
Or he could have been on mushrooms, correct?
It's a substance that still would have impaired him.
He could have been on ketamine, correct?
My understanding was he was intoxicated by alcohol, but regardless of what the substance was, he was still intoxicated.
And did you do any field sobriety tests on Mr. Slaughter?
No, ma'am, I didn't.
Okay. And on to the implied consent issue. You testified just now that you called an EMS to come and get Mr. Slaughter, right?
I did.
And after he left the scene, things calmed down a little bit. You watched the video back, right?
I did.
You, in fact, met with other officers and sort of discussed a plan to recover the firearm and where it might be, right?
Yes, ma'am. You
then actually recovered that firearm, correct?
I did.
And then you went to Grady to meet with Mr. Slaughter.
I did.
Okay. And also in the meantime, you had also spoken with the other, the witness, the female who was in the car with Mr. Slaughter as well, right?
I did.
And you also had to deal with Georgia Power, didn't you, because of the utility pole situation?
Yes, I don't recall when they came out there, but that's
Right.
something they had.
Right, so you had to stick around for a little while, right?
I did.
And then you went to Grady to see Mr. Slaughter. And at that point is when you read him his implied consent rights, correct? And you testified that he refused.
Yes, ma'am.
And at that point, you didn't know whether he had been treated with anything medically.
I don't know if he was given anything or not.
So you didn't know whether he was
Don't
under.
talk over each other.
Mhm.
Let
Go
him
ahead.
finish and then you'll be able to follow up.
I sent another trooper with him to observe him at the time. So you would have to ask him if he was given anything or there may be medical records of it if he was. But to my knowledge, there wasn't anything, but like I said, I wasn't there.
Okay, and you just testified for Ms. Clark that when you read those rights to him at that time, you did so because that's when, that you did so based on his watery eyes, slurred speech, and other sort of signifiers to you, right?
Yes, ma'am.
But he also had those things when you first arrested him, correct?
Correct.
And when you put him in the back of your patrol car and you had full control of him, correct?
Correct.
And when he was sitting there for a few minutes before he began vomiting, et cetera, right?
Correct.
No further questions, Your Honor.
All right. Ms. Clark, do you have any follow-up for Lieutenant Gass?
Yes, Your Honor. Can you state, the amount of time that, when you put the defendant in the back of your car? From the, do you know like about how much time went before he was picked up by Grady Hospital? Just minutes? if
It
you
was
could-
within 30 minutes. The attempted traffic stop, or when I observed the car to begin with, was 9:24 p.m. My recollection from watching the video earlier this morning was that he was picked up within 30 minutes. And then the time that I've got documented that implied consent was read was at 12:05 a.m. the following day, so within less than 3 hours.
So I follow this. You think it was about a half hour from when you initially engaged with Mr. Slaughter? Either you saw him or you put your blue lights on and he got picked up by EMTs. So that's 30 minutes. All that additional time is he's down at Grady and you're doing all the things you were asked about, finding the gun, dealing with Georgia Power, making sure the passenger is okay. Okay. What happened with the passenger? She couldn't drive home.
No, sir, she was fine. Somebody, I believe, picked her up. I don't recall exactly, but she was okay. But shortly after the crash, she turned around and walked back to the car while I was still trying to deal with him to get.
Okay. But you all didn't just leave her there?
No, sir.
Okay.
Blood alcohol content actually dissipates over time, correct? So a lapse in time in testing could actually benefit the defendant.
Correct.
No further questions from the state, Your Honor.
Anything else?
No further questions.
All right. Thank you, Lieutenant. Appreciate your time. Ms. Clark, any other witnesses?
No other witnesses from the state, Your Honor.
All right. Any witnesses for the defense?
No, Your Honor.
All right. The record is closed. I'm happy to decide this based on the record made. I'm also happy to hear any argument if either side has argument.
Yes, I do.
All right. Why don't you get us started as the movant?
All right, Your Honor. Well, I will make it short and sweet because I believe Lieutenant Gass's testimony spoke for itself. I apologize. Not feeling great today. The statute of implied consent requires that it be read at the time that all of those things become aware to the officer. So the watery eyes, the bloodshot, etc. It is imperative under the statute that that the implied consent be read at that time. It is in the language of the statute. Governor Brian Kemp particularly wanted it so, and there have been many changes to that statute over the years to actually tighten those requirements so that officers must be diligent and must be giving that warning or reading those rights in a time close to the actual arrest of the defendant. In this case, Mr. Slaughter was arrested, he was apprehended, he was cuffed, he was put in the back of the patrol car. And even if they were read 30 minutes later, that's a significant amount of time. Yet here we have a period of waiting where the officer could have read him those rights and did not. And then Mr. Slaughter goes to the hospital, at which point undergoes some sort of medical care to which the lieutenant had no real way of knowing. And only after all of that, almost 3 hours later, are the implied consent rights read to Mr. Slaughter. He refused it. Doesn't matter whether or not it would have helped him. The fact is that the process itself was botched, and thus the refusal of that implied consent must be suppressed. Additionally, the officer did not, we have seen nothing to show that it was read correctly, that the actual language of the statute was read correctly. I know we have a lieutenant with a lot of experience, but again, the language changes constantly. That green card changes. Even with the green card, officers mess these things up all the time. We've seen zero evidence today that it was read correctly. All we've seen is that it was read at about 3 hours later than the time in which Mr. Slaughter was actually arrested.
Do you have, as I broadcast at the beginning, we're operating in a space with which I'm less familiar than suppressing an identification or the reasonableness of a stop or a search, et cetera. Is there case law that helps judges draw that line more clearly than it needs to be close in time? I trust you that that's what the statute says.
Yes.
What's the statute, first of all?
The statute is 46. Hold on, I have it somewhere.
If it's in your motion, I can find it there. But
You're right, a copy of the statute if you want.
I just
Thank you.
need the citation.
You want to read it or?
It is, the citation is, sorry,
I believe it's 4567.1.
46, 392, Your Honor.
What?
So it should have
Oh, no.
three numbers?
Implied consent is 40-5-55.
Okay. All right. So my question was, and I don't mean to put you on the spot, especially if you don't feel well, I'll look it up as well. But is there case law out there that helps courts navigate the fuzziness of as close in time as possible? Whatever it says in the statute, is that well, it's got to be 30 minutes no matter what. It doesn't matter if the driver's head is mashed in because of the accident, or the situation dictates.
Your Honor, I don't have a site offhand right now. I can find one. I will say, I don't think we're dealing with a fuzzy issue here. This isn't 20 minutes, 30 minutes. This is 3 hours.
Okay, I follow that.
Yeah.
The math I get. Where I think there is some play in it is the decision not to give it there at the scene, where the only evidence of record is that your client can't really provide basic biographical information, says he's heavily intoxicated, and then proceeds to get sick all over the back of the car. I could understand, and I bet there's going to be case law that says when you're in a situation like that, why would you give it? Because then the defense will be, there's not a meaningful consent or lack of consent because my client was effectively non-functional. Now, clearly, from that time to 3 hours later, his head cleared up a little bit because they had Lieutenant Gass and your client a more sober and meaningful interaction at Grady. And so I'll need to work through, well, is it the obligation of law enforcement to have some other officer do it? And we know someone was there because someone followed him down. Or does it rest on the shoulders of the arresting officer who actually made those observations and the other one didn't? So I don't know. There are variables at play here that make this not so clear that it should have happened there at the scene. But to your point, I think it's a good one. We've got I'm gonna call it a 3 hour window, maybe a little more, a little less. That window where your client's at Grady and nothing happens on that front until Lieutenant Gass is able to make it there.
Mm-hmm. And I do think this is an issue that comes up a lot in DUIs. And from what I've seen, the fact of a defendant being intoxicated at the time the implied consent is read does not seem to play a part in my experience, but I'm happy.
And you may be right. That just strikes me as very peculiar. If I were the defense attorney, I'd say, well, wait, don't hold that against my client. He didn't even understand the words because the officer just said he's so drunk, he couldn't give me his own name.
Yes.
Okay. I'll learn something.
So would you like additional briefing on the issue?
You're welcome if you want to send cases. That's all you need to do. Judge recommends you read these 3 cases. Obviously copy Ms. Clark on that, but that's all I need is you've articulated clearly your point. And in the absence of case law, I'll have to sort of grope around, but with the addition of case law, it might crystallize it like, this is sort of strict liability for law enforcement. And that's too bad for them because I don't know what other options they had other than, saying on the radio, this guy, I could see glassy eyes, and someone who didn't see it being the one who does the implied consent. So I invite the case law, but you don't need to make it more formal than that.
Understood.
Okay.
All right.
Appreciate it.
Your Honor.
Ms. Clark?
Yes, Your Honor. And I'll go ahead. There is case law, Your Honor, that is on point to your question.
Yeah.
Let the record reflect, I'm providing defense counsel copies of the cases that the Georgia courts have spoke on this issue. But Your Honor, before I do that, I wanted to point out, though opposing counsel referenced the statute implied consent to chemical tests, there is a part, and I have a copy of the statute for your convenience, Your Honor, as the 3rd attachment, I think there. But a part of 40-5-55 in section A, there is a part midway through the statute that says the test or tests shall be administered as soon as possible to any person who operates a motor vehicle upon the highways or elsewhere throughout the state who is involved in any traffic accident resulting in serious injuries or fatalities. Then it says, subject to code section 40-6392, the requesting law enforcement officer shall designate which of the tests shall be administered. Your Honor, there was a traffic accident at this scene. It wasn't a fatal accident, but the statute does indicate as soon as possible, as soon as the officer is able to, as the There has been evidence that has been presented by the state that show that the officer, the defendant, actually tossed a gun. There was a chase. And there was an also Lieutenant Gass actually took time to retrieve the weapon. And so it seems that there was no, based on the testimony, no indication that there was an attempt or a intentional delay based on the circumstances. There was also a passenger that was in the car that the Lieutenant Gass referenced was in the car. He was ensuring that that passenger was checked by authorities. Further, Your Honor, there is if you'll bear with me one moment here. Let's see. In terms of the implied consent, the cases that I have,
Man, how many people over there with you? Man, they is not picking up the phone, Pandora, and I need to use the restroom.
under,
Let me call Brooks. I know it's like more than one.
let's see.
What are you looking for?
I was just looking for the implied consent, the specific case, because the cases I have are,
Well, why don't we do with you what I offered up to defense counsel, which
Okay.
is that you're welcome to shoot an email to me and defense counsel saying, I recommend you look at these 2 or 3 cases that address that question that is raised by the language in the statute, which says as soon as possible. And there are factors that to me support the notion that it really wasn't all that practical to administer the implied consent to Mr. Slaughter there at the scene. But then we've got the 3-hour window at Grady, where clearly by hour 3, Mr. Slaughter was in a position where it could meaningfully be administered. And that might not have been as soon as possible if at hour 2 he was ready for it. And I don't mean to suggest he was held too long. He was going to jail anyway. That's not the analysis here. It's just whatever case law says about that clock that starts ticking from the moment an officer notices that someone appears to be driving while impaired. And Lieutenant Gass has, I think, very clearly articulated that. And that would have been known at the time he's interacting with Mr. Slaughter on the side of Collier Road with the exploding transformer and all that kind of stuff.
okay.
Were there other things you wanted to add?
No, Your Honor, just the fact that I know that defense counsel referenced not seeing the implied consent, but the standard here, as you know, as you well know, as everyone knows, that is preponderance of the evidence. The state has provided Lieutenant Gass, a very experienced officer, and it's the state's position that his testimony came across as credible and consistent with what he's reported.
Okay.
So for those reasons, we're asking you to deny the motion to suppress.
I have a question for you. Mr. Slaughter does what for a living in Arkansas or wherever he works? If you know, and if not, he can tell us.
Jay, can you hear me?
Yes, ma'am.
Do for a living. Go ahead, tell the court.
Well, right now I'm just stay-at-home father. I stay home with my children because I'm actually on pretrial in another case, and I don't like this case that I have here in Georgia is preventing me from getting my license secured, so I'm not able to drive back and forth or anything like that. So I'm staying at home with my 2 children who are in the back now while their mother works.
Okay, what work would you do if I was able to mail you a driver's license today, so you got a license, what work would you do?
And pretty much anything available.
What kind of work were you doing in December of 21?
Well, actually, I was into the music business, but it's kind of slowed down a bit since with all of this that's going on.
Okay, but you're not like a truck driver or something?
No, sir. No, sir. I was road managing for a friend of mine who was all over the States as a rapper.
Got it. Okay, so you traveled a lot, but not professionally in the sense that you drive a big truck or a gas truck or something like that. You just needed to get around because the person you were repping or supporting was going lots of places.
Yeah, we did a bunch of shows.
Got it. All right. Anything else from the state?
No, Your Honor. The state will be submitting additional cases. I could find the case after, but I did after I actually left the podium. But the case is actually Edge v. State, Your Honor, where the Georgia Appellate Court indicated that there a 2-hour delay before the defendant was advised that the defendant's implied consent rights was not untimely because the delay was caused by a newly hired officer's call for assistance to confirm the officer's determination that the defendant was driving under the influence.
What's the citation for Edge?
The citation is 226 Georgia App 559. It's 487 SC 2D.
I just need the first one. That's an old case. I'll have to see where it's gone from there. But that's a helpful place to start. And again, I invite the defense to submit as well. The other case that Mr. Slaughter has, are you handling that?
I am not, but I am in close contact with his attorney in that case.
Is that an Arkansas case or also a Georgia case?
It's an Arkansas case.
Okay. I ask only because if we're trying to work things out, oftentimes it helps to have someone who's plugged in with everything. And it sounds like you are, which is great. Okay. Mr. Slaughter, do you have any questions for me? I will take this under advisement. I will enter an order soon that either grants the suppression or denies it. That will allow you and your lawyer to know more about what's coming in or not coming in your case. You have a final plea date. Your schedule matches Mr. Farmer's. A final plea date of January 11th. You'll need to be here for that. That's not a dial-in one. If you don't resolve your case by that date, then you are on our February trial calendar and you'll need to be here for that as well. So 2 different times I'll be seeing you early in the new year if the way you decide to travel is by going to trial, which is fine. It just means I'll see you that second time as well. Your lawyer knows this stuff. She'll talk to you about it, but I just wanted you to know what's coming up, okay?
Okay.
Any other, do you have any questions?
I mean, I'll just give him my lawyer. I'm guessing.
Good. No, that's the right channel, but sometimes a defendant like, Judge, why did this take so long? Or when am I coming back to court? Those I can answer. The deeper questions about the meaning of life and what this case is going to look like for you, that's why you have this lawyer. All right, thank you.
Right, okay.
You good?
Yes, sir.
Okay. Well, thank you, everyone.
Thank you, Your Honor.
Thank you, Lieutenant. Appreciate your time. Ms. Clark, I got to interrupt real briefly. I'm sorry. We're going to start at 1:30, not 1. My kid's here today and I got to feed him. And we won't be able to do that in 23 minutes. So 1:30, I don't know if you're on the next calendar. We have something that was starting at 1, but now it's not till 1:30.
I have one case for final plea.
Okay. Oh, Mr. App's case. Right. Okay. 1:30.
Okay. Thank you.
You will not have the pleasure of my presence.
Well, I appreciate you being here this morning.
Always good to see you.
How old's your kid?
13, and he's hungry.
Oh, nice.
That's a bottomless pit.
Yep.
Boys, I survived it, yes.
I'll have to follow up with the HR. You don't want with people level. I'll get to get. Thank you. Hi, thank you for holding, Sean. So I did reach out for assistance. So that is just an automatic email that goes out when you have missing miles, but you'll have to follow up with your Ecolab HR. They have to give that permission
Okay. Ms. Nelson, can you hear us?
Yes, I can.
Great. Okay. We had three things scheduled for this afternoon, but one has been postponed after a meeting this morning. Four things, two have been postponed. We have a motions hearing with Mr. O'Neill. That's what Mr. Shepherd is here for. We had a motions hearing in the Denzel Thomas situation. Mr. Harvey didn't make it. He may be online. He is online. We're just going to talk scheduling about that to figure out when we can get Mr. Harvey. And then Mr. Apt was going to be here. I don't know if he's online.
For his report, Judge.
We're holding for his report. Excellent. Okay, I'm not the latest one. Then why don't we talk with Mr. Harvey about scheduling the Thomas matter and then take care of Mr. O'Neill's situation, if that works for everyone. And Mr. Shepherd, you can migrate on up. It's gonna be your table up there. We don't need to take this part down. So Mr. Thomas, we were trying to squeeze in a motion to suppress for today, but didn't consult with Mr. Harvey's calendar, and he got pounced on by a whole bunch of other litigation managers around the state when they learned that there was a break in the action with YSL. You've already strode up to the podium. Anything you want to say first, Mr. Jordan?
No, Your Honor, just the same thing that I communicated in the email, that we were finally able to get the phone dumps over to Mr. Harvey via Miss Jamie Roberts, who is with his office. And a new offer has been extended in the case as well.
Okay. Mr. Harvey, good afternoon. Just like that, he went mute and turned the video off. He managed to get the video back on. That's a start. Mr. Harvey, do you know which button to press to unmute? Excellent. Someone pressed it for you. Can you hear us?
I can't hear anything.
Pardon me?
I cannot hear you if you're speaking to me.
Well, you managed to respond. Oh, okay.
I think you have to unmute.
Ms. Rivers, can you hear us?
Yes, I can.
Okay.
The speaker might be muted.
Yeah.
Or his speaker might not have any volume on it.
He keeps
it's you. It's you.
It's not.
It's you.
Send him a chat to see if he.
You gotta unmute me.
One
He
else
has to unmute me.
and hear you. Is that backwards?
No, it's perfect.
That's perfect.
But well.
Your speaker.
I'm going to write that next. Is your. I have to make him look up.
Oh, he's writing.
Yeah, no way to do it.
Yeah.
Ah, there he goes.
How do you get that off? How do you get that off there?
I can't hear you. You have to unmute you. You are unmuted. This is the way he gets out of court.
I'm unmuted.
Can you hear us?
He has to,
Hey, Bruce. Is your speaker volume on? Look at the little icon down at the bottom right of your screen and see if there's an X on your speaker.
yeah.
So your speaker might be off because we can hear you and everybody else on the Zoom can hear Judge McBurney. Sorry, Your Honor.
That's all right.
Thought this might be quicker than the notes.
No, this is great.
Okay, no.
Can you hear us?
Yep.
So if you hang up, can you still hear us?
Yes. So I think
See, I have a future in IT.
You do, and Mr. Harvey does not.
some troll came in and changed the settings on my on my computer. I think it was some guy named Kenny Shepherd or something.
Yeah, I think it was someone from the DA's office crack surveillance team wanting to know what's going on, the defense strategy.
Yeah. Okay.
So,
not too crack. Okay.
So what I wanted to sort out from you, Mr. Harvey, is your best sense of when we might, the suppression hearing shouldn't take too long, but we need a hour of your time, hour and a half. Did Judge Glanville set a routine of no Fridays in court, and so we just need to get in line on a Friday, or what's the best way to do this?
No, he has not yet. What he has said is once we get sort of structured next year and have a regular routine where it's not broken up by the holidays, he would consider giving us Fridays dark.
Okay.
I know that he is going to give us the week of Martin Luther King, that entire week off. Now, I don't know what date that is. I'm sorry. But
conveniently, that's the judges' conference. So he wisely picked that because he's got to go to the judges' conference.
Okay, I see. Well, can we just waive your presence?
Yeah, go for it.
Hash it out in the MMA ring or something like that.
Yep. But you'll bring Monis and he'll kill everyone.
That's exactly right. That is exactly my tag team partner.
Exactly. And you very quickly tag. We may be able to do it Tuesday morning of that week. So I'll get with Ms. Nelson and then she can check with you and Mr. Jordan. But that may be our next available date until you get that cadence with Judge Glanville that says we're taking Mondays or Fridays or whatever it is he decides to take on.
That's great. And Mr. Jordan needs to decide what we have a motion to suppress, like the phone dump, for example. And as far as I know, the state has not made a final decision as to whether they were going to use that at all. So we may be able to avoid at least a hearing on that part of it by the state saying, yeah, we've had some time to think about it. We're either going to use it or not going to use it. So that may obviate some of that. Is that correct?
That is correct, Your Honor. I've gone through the phone dump. I don't have a final answer for Mr. Harvey in the court today, but I don't see anything particularly useful that Mr. Thomas or Ms. Kelly had in their phones, but I'll make sure to have a definite answer long before the 15th.
Was there another part to the motion to suppress? I thought it was just the phone stuff.
From my understanding, Mr. Harvey, and correct me if I'm wrong, it was also the search of the home, which yielded the firearm and pictures.
Okay.
And it was also the phone dump were the two major items of the motion.
Okay, so that's why Mr. Harvey was saying this would shorten the hearing, but it wouldn't eliminate the hearing. And I'm all for a focus if we can get it.
Yes.
And since we can't do the hearing today, that gives you more time, Mr. Jordan, to assess what you're going to do with the phone. You can make that official at the hearing. Obviously, the sooner you can let Mr. Harvey know, he doesn't need to prepare for the phone part of it if you're not going to use it.
Yes, Your Honor.
And if you ever change your mind, then we just need to litigate that piece. But it'd be good if you can reach a state of semi-certainty before we set this down again for the hearing.
Yes, Your Honor.
Okay.
That's a Daubert standard, by the way.
Yeah, semi-certainty. Ms. Nelson is saying that Tuesday morning would work. Is that currently open for you, Mr. Harvey? I'll get specific with numbers. That is the 16th.
Let me look. In my inability to get two screens at one time,
Yeah, now it's going to go mute on us.
or something. No, I'm going on my phone for that. Let's see. I don't even know how to get to January on my phone. Let's see. The 15th is a Monday, correct?
The 15th is a Monday, so we're talking about the 16th.
16th. I've got a Zoom status hearing in federal court, Judge Boulay at 10 o'clock. That should not take very long. Other than that, that looks like a good day, Judge.
Okay, so would you be able to be here by 10:30? Would we say 11?
How about 11?
11, okay. Why don't we set that down? Ms. Nelson will publish a calendar, but you write it in some space that protects that. And we'll say 11 on the 16th. Now, if I'm remembering correctly, Mr. Thomas lives far away. He's on the call now. It looks like he's in a car, but he's not local. Is that correct?
You gotta unmute, Denzel. All right.
I'm local.
Oh, he's local. Good. So he could be here for the suppression hearing.
Yes.
Excellent. That's my preference. We just had a couple of hearings this morning where someone was in Arkansas, someone was in New York, and it was a little problematic that they weren't here, but what we were doing made that work out. So great. So Mr. Thomas will be here in court with you 11 a.m. on Tuesday, January 16th. We'll get a calendar published quickly so we can block that off. Anything else, Mr. Jordan?
Nothing further from the state, Your Honor.
If you could try before that date to sort out using phones, not using phones, and let Mr. Harvey and Ms. Nelson know that, just copy me as well. Then we'll know, hey, it's just about the search of the house versus phones also.
Yes, Your Honor.
Okay, sounds good. Mr. Harvey, anything else in connection with Mr. Thomas's case?
Thank you. Thank you for allowing us, Mr. Thomas, to come on by Zoom. I had a wonderful time up in Cartersville this morning.
Excellent. Well, as long as you're happy. Mr. Jordan?
Oh, yeah. Thank you.
Yeah. Anything else, Mr. Jordan?
No, Your Honor.
All right, we've covered the Thomas matter. We'll see you all on the 16th, 1/16 at 11 a.m. Thank you.
Thank you. See you, Kenny.
Bye, Bruce.
See ya.
All right.
Please be excused.
You may. Thanks for being here. Ms. Nelson, was Mr. Apt going to show up virtually or in person?
Sent an email. Let me see what he said. I saw an email from him a minute ago.
I'm fine either way. I just won't be paying attention to the screen. I'll notice if he walks in.
He's in 7F.
He's in 7F, so he'll be coming here.
That's my expectation.
Okay.
He's only one floor away.
Okay, good. Then let's turn to Mr. O'Neill. Before we bring Mr. O'Neill out, I wanted to understand what we're hoping to cover today. If I look back at my notes, there was immunity withdrawn, photo lineup shown to Mr. Jackson, 2 statements, cell phone searched, and question about whether Mr. Jackson's blood had been tested. There is a motion in limine that Mr. Shepard filed more recently than that hearing. We could talk about it now, but it's also easy to handle just before trial. Mr. Abate, what were you prepared to cover today?
Your Honor, I believe the only thing that is necessary to cover today would be the motion that Mr. Shepard filed on behalf of his client as relates to the cell phone records that were received by the Texas vendor in relation to your warrant. As it relates to the cell phone extraction, you may not have written in your notes, it's a busy morning from when we spoke about it, but it's still, for lack of a better word, spinning. They haven't been able to crack the phone.
Okay.
But it's still plugged up to the devices in order to, in an attempt to get into the phone. As it relates to the statements, there is no statement from the time he was arrested. I believe it's February 24th of 2022. And then the statement that he makes to Detective Bender on November 16th of 2021 is not even a suspect. She's going down the list, calling every member of security from a list that she received from the—
Calling on the phone?
Correct.
Okay.
And one of the 13 people she called on November 16th of 2020 was Mr. O'Neill. Had a fairly short phone call. that resulted in, her hanging up and continuing her investigation.
It was a non-custodial, it sounds like non-interrogative, if that's a word, encounter.
Correct.
Okay. Is there a recording of that, or it would just be Detective Bender saying, I called 13 different people who I was told had been working security at one point or another at this night spot?
There is not a recording. Detective Bender in detail described her report, that at the time that she was using her digital recorder, there was some sort of malfunction at the time that she was transferring it to either her computer or her desktop computer or her laptop. And in the process, it was lost, but she had described each one of the 13 recordings in detail as it relates to what was asked and said during those recordings in her 43-page report.
So it sounds like a long report. Is there anything from the detective's brief non-custodial conversation with Mr. O'Neill that you'd plan to use at trial?
I do not plan to use the entire interview. He talks about that he no longer worked at the club at the time, that he had just been there earlier on Saturday, that he doesn't go there on Sundays. This occurred on Sunday, and things of that nature.
Okay, so he has said some things that might not be helpful to him, but he was not a suspect. She was, as you said, effectively canvassing the list of security folks.
That's correct.
Okay. I don't want to get much more substantive because Mr. O'Neill's not out here yet, and I'm not keeping anything from him. I just wanted to scope out what we're doing. What about the photo lineup?
Yes, I apologize. That would be a relevant thing to cover today. Detective Churchill did show the lineup to the surviving victim, Mr. Jackson, who Detective Churchill is present outside.
Okay, so we can do that. Is that all we'd cover today?
I believe that's all the substantive motions. The last one that you referenced, or Your Honor referenced, was in relation to a motion to test Mr. Jackson's blood. I've had no success in getting through Brady, whether they have kept the blood or not. And I'll be candid with the court. I didn't try very hard after the first couple of times because the state's under no obligation to go to a private hospital and have that private hospital give us over blood to then take to the GBI.
Okay. All right. So Mr. Shepard, it sounds like what we'll cover today is the photo lineup that was the identification process with Mr. Jackson and the detective. When your client gets out here, I want you to get on the record your thoughts about the statements that we just heard about. It also sounds like the phones, currently nothing to suppress because nothing for the state to use. Anything you want to add procedurally?
I think the state did say they do have some records that were recovered from the cell phone company by a search warrant.
Okay, so cell phone records as opposed to what's on the cell phones themselves.
And those are two distinct items.
Okay. Did you end up, Mr. Body, getting from, let's pretend it was T-Mobile, records from T-Mobile?
We did, Your Honor.
Okay.
I prepared to move forward on that one. I have a certified copy of the affidavit and warrant for Your Honor to determine based on the four corners if there's probable cause.
Okay, great. We'll handle all that stuff. Anything else, Mr. Shepard, you want to talk about before we bring?
Motion in limine the unreliable testimony under 24-7-702, and that is that there is video, but in the video that the detective should not be allowed to testify, oh, the person in the video is the defendant, because that's not scientifically reliable.
Okay.
And if it is for him to say that's scientifically reliable, I've got 20 family members who will come in, look at the video and say, no, that's not my whomever.
Okay.
Because then their testimony is also scientifically reliable.
Got it. All right. Let's bring Mr. O'Neill out, please.
Hey, how's it going?
All right, we'll get on the record in 21 SC 179984, State versus O'Neill. Mr. O'Neill is out here in court with his attorney, Mr. Shepard. We have Mr. Abadi here for the state. Good afternoon, Mr. O'Neill.
Good afternoon, sir.
I spent a few minutes speaking with Mr. Shepard and Mr. Abadi about what we're going to cover today before we brought you out, just so I knew procedurally what we were going to discuss. Mr. Shepard filed a motion to suppress an identification that was made of you out of a photo lineup. We're going to talk about that. And then we're going to talk a little bit about some cell phone records that the state obtained with a search warrant. So this is not anything directly from the phone, but from the cell phone company. And then we may talk about a motion that would prevent strangers from looking at the video, the surveillance video, to say, I recognize so-and-so in there, but I'm not sure we'll cover that today. Let's start with the photo ID.
I have a question.
Yeah.
I'm assuming there's a court reporter somewhere typing this stuff, but I don't see one in the courtroom.
There's not. Ms. Rivers is here electronically, and I confirmed her ability to hear us when we were trying to hear Mr. Harvey, and Mr. Harvey was trying to hear us. So Ms. Rivers is taking all this down.
That Karen Rivers?
It is, in fact, Karen Rivers.
I have to request transcripts.
Okay. And it's always good to check when there's not a court reporter right here, whether we've got that covered, but we do. So, Mr. Abadi, if you would proceed with whatever evidence you want to put up concerning the photo identification.
Yes, the state would call Detective Churchill.
And if while we're doing that, can I just recap to my client what happened while he was in the back?
Sure.
And that is that there were two statements. One statement on, well, when you were arrested, there is no statement. So there's not going to be a hearing about any statement from the day you were arrested, which was February 24, 2022. The November 16 telephone conversation you had with the detective was non-custodial, so we can't suppress that.
Okay.
So everything that was said during that telephone conversation, unfortunately, the recording has been lost, but the detective will testify about that. They cannot get anything off your cell phone, but that doesn't mean that in the future, that will not become an issue. And they do have your cell phone records from whatever your cell phone provider is. And also the one surviving person, Rodriguez Jackson, has identified you as the person who shot him. So we'll talk about that as well today.
What about the motion?
What about what?
Motion to sever.
That has been denied. The motion to sever has been denied.
Correct. All right.
Swear affirm that testimony you will give will be true, the whole truth, and that's what you said, God.
I do.
So, yeah, I see what you always say. Can you state your name, is that right?
My name is Detective Jeffrey Churchill. I'm employed with the City of Atlanta Police Department.
Say good afternoon, Detective Churchill.
Good afternoon.
Can you tell the judge how you are currently employed within the City of Atlanta Police Department?
I've been employed with the City of Atlanta Police Department since 2007. I'm currently on the homicide unit.
Okay. And as part of your normal job responsibilities and duties, do you assist other detectives within the homicide unit with cases in which they are assigned as the lead detective?
Yes, sir.
And did you assist Detective Bender in the case that involves, I guess the case number was 203140296. It was an incident that occurred on November 9th of 2020 at the VU nightclub 2997 Campbellton Road?
Yes, sir.
And as part of your, I guess, assistance, did you assist, I guess, after the initial investigation occurred on scene at the nightclub at the scene of the shooting?
Yes.
And were you asked to go to Grady Hospital on November 25th of 2020 to show a photo lineup to a surviving victim, Mr. Rodriguez Jackson?
Yes, I was.
Okay. And was the lineup created by you, or was it created by Detective Bender or somebody else?
It was, I do believe, Detective Bender, not by me.
Okay. And did you know at the time that you were going to show the lineup to Mr. Jackson, if the lineup contained anyone that she had developed as a suspect or someone related to the case?
I didn't know I didn't know who the suspect was or anything.
And is that pretty common when you are assisting in showing a lineup to a witness, victim, somebody related to the case?
Yes, that's common.
Okay. And on November 25th of 2020, can you describe, if you can recall, I guess, where within Grady Hospital did you meet Mr. Jackson?
It was on the 6th floor in a room. He was sharing a room with another patient of Grady Hospital.
Okay. And was he, I guess, still receiving medical treatment for his gunshot wound?
Yes, he was.
Okay. And at this point, when you arrived to his room on the 6th floor, had you ever met Mr. Jackson before?
No.
Okay. And when you arrived and I guess introduced yourself to Mr. Jackson, did you have any sort of form of recording, whether it be audio or video, so you could record your interaction with Mr. Jackson?
Yes, I had audio recorder.
Okay. And were you able to, after completing your interaction with Mr. Jackson, able to, I guess, take the audio recording off either your phone or other recording device and transfer it to the lead detective, Detective Bender?
Yes.
Okay. And I want to show you what's been marked as State's Exhibit 2. Do you recognize State's Exhibit 2, sir?
Yes, sir.
And how do you recognize State's Exhibit 2?
I reviewed it and signed my, put my initials on it and dated it.
Okay. And what is contained on the disc or the CD on State's Exhibit 2?
It's an audio recording of my interview with Mr. Rodriguez Jackson.
And in your review prior to this hearing, did it fairly and accurately depict, as you recall, your interaction with Mr. Jackson at Grady Hospital on November 25th of 2020?
Yes.
Your Honor, this time the state would tender what's been marked as State's Exhibit 2 into evidence.
Mr. Shepherd, any objection to States 2 being admitted for this hearing?
No objection for this hearing.
All right, it's admitted.
Now, Detective Churchill, you had said previously that you had never met Mr. Jackson before, correct?
Correct.
And was this, I guess, the first duty or way you were helping assist Detective Bender as it relates to just this investigation?
Yes.
And I want to show you what's marked as State's Exhibit 1. Look at it. Let me know if you recognize it.
Yes.
And what is or how do you recognize State's Exhibit 1?
It's the photo admonition form that we read to our victims, our witnesses, and it's a 6-pack lineup, photo lineup.
And is it the same admonition and 6-pack photo lineup that was shown to Mr. Jackson on November 25th of 2020?
Yes.
Does State's Exhibit 1, is it a fair and accurate copy of that lineup that you just referenced and we've spoken about in the last couple of minutes?
Yes.
Your Honor, at this time, the state would tender what's been marked as State's Exhibit 1 into evidence.
Same question, Mr. Shepherd, any objection to admitting Exhibit 1 for purposes of this hearing?
No objection for this hearing.
Admitted.
Thank you, Judge. Now, can you describe for Judge McBurney a little bit about when you first saw Mr. Jackson, what kind of condition he was in the hospital room?
He was laying in bed and he was sweating a little bit, and he said that I asked him, was he okay? He said, yeah, but he was in a little pain. And I do believe, I'm not sure his medical condition, but I believe he couldn't move his extremities, that he was possibly paralyzed.
Okay. And based on what you, I guess, had been informed as it relates to the investigation, were his injuries that he was in the hospital for related to the shooting on November 9th of 2020?
Yes, he said he was shot.
Okay. And when you were interacting with him, was he able to, talk and respond to any questions that you had prior to showing the lineup?
Yes,
Okay. And at the time that you started your recording device and you began asking questions, did you read him page 1 of State Exhibit 1, the photo lineup admonition?
I did.
And did you read it to him verbatim?
Yes,
And at any point prior to reading him or during reading him the photo lineup admonition, did you make any suggestions or tell him who he should pick?
no,
Did you reference the photographs other than the fact that behind the photo lineup admonition or after you finish reading it, you provide him 6 photos for him to review?
I provided them 6 photos.
And is that all that you told him as it relates to the photos, is what you read in the photo lineup admonition?
Yes,
And at any point after reading him the admonition, did you threaten him in any way if he was unable to make an identification?
no,
And did you make him any promise or benefit if he was able to make an identification?
no,
Did you give him any sort of guarantees of benefit that would come his way if he made an identification?
no.
Okay. Now, after reading Mr. Jackson the lineup admonition, can you tell the court what you did next?
Well, I interviewed him, I showed him the ammunition and he chose one of the photos as a person involved in the crime.
Okay, and do you recall which photo, well, are the photos numbered?
Yes,
And do you recall which number photo he selected?
it was number 4.
Okay, and I want to show you what's marked as State Exhibit 5. Do you recognize State Exhibit 5?
Yes.
And how do you recognize, or what is State Exhibit 5?
This is the, well, it's the photograph without the writing on it is the photograph he chose.
Okay.
The person, number 4 was this person.
Okay, and does State Exhibit 5 fairly and accurately depict the same photo that's depicted within State Exhibit 1, I guess picture number 4 that you just referenced to?
Yes,
Your Honor, this time the state would tender what's been marked as State Exhibit 5 in evidence.
What is States 5? I can see it, but is that a booking database? Is that a driver's license database? What's
Yes.
that from?
that's a driver's license photo.
Okay, so you all have, meaning law enforcement, have access to DMV's database. If you're looking for someone in particular, you could type in Robert McBurney, you'd get my picture, and then you could, let's find 5 more guys who kind of look like him, super handsome, slightly balding, nice beard, but so that they match.
Exactly, yes.
Okay,
Mhm.
but that was a known, you didn't know it at the time, but that was the known for Detective Bender.
Yes, yeah, I wasn't giving this information. I was just giving the photos. I didn't know who it was.
Got it, okay, but most of all, Exhibit 5 comes from the DMV database.
Yes, sir.
Okay, Mr. Shepherd, any objection to the admission of Exhibit 5 for the purposes of this hearing?
No objection for this hearing.
Okay, admitted.
Thank you. Now, Detective Churchill, after Mr. Jackson picked number 4, can you tell the court, did he want to sign his signature or any sort of identifying information on the admonition form after you requested?
Initially, no, he picked it out and he was, he didn't want to sign it. I asked him, I just instructed him the next step was to sign the form. And he didn't want to, he was hesitant about signing it.
And after he expressed that, did he express his hesitation had anything to do with fear for himself or his family based on what he had experienced?
I think that might be a leading question.
Why did he, what did he tell you about why he didn't want to sign it?
He said, he gave me 3 states that his family lived in. He said he's feared for his family. And he was like, my family live in, I believe it's 3 different states and even in Georgia. And he was scared that it would be retaliation against his family if he signed the form, if he wrote his name on any other paperwork.
And on the first page or on the admonition form, is there can you tell the judge, is there a place where his name was but was crossed out?
Yes.
Okay, and can you tell the court and counsel, I guess, what is written next to, is there a name that's written next to where Mr. Jackson's name is crossed out?
Right, that's a name. I think he originally put his name and then he crossed it out. And he said he wanted to use his brother's name or something. And he wrote a name there.
Okay. And can you tell the court, based on your conversations with Mr. Jackson, exactly why he used a different name than his own?
Yes, he just said he was scared and he just didn't want any retaliation against his family members.
And is the entire interaction that we've kind of talked about and your entire interaction with Mr. Jackson contained on State's Exhibit 2, the audio recording of this photo lineup procedure?
Yes.
Detective Churchill, can you tell me how you handled the actual, thank you, identification? Meaning, did you hand Mr. Jackson one picture at a time, or you gave him all 6? They were in different folders. It was one folder. You threw them in the air and he looked at them?
No, sir, I gave him a folder. It's ever which way the lead detective give us the folders, that's the way we present it. And it was like one folder with 6 different pictures in it there. I don't know who the suspect is, so they could be shuffled. They could be in any type of order.
You received that folder with the pictures in it from Detective Bender. You didn't tinker with it, said, here are the pictures.
Right. You know, she wasn't at work, so I do believe it was on her desk. And I was called and asked to go down to the hospital. And
okay. That's a helpful clarification. So you just picked the folder up and then took it to the hospital. While Mr. Jackson had an opportunity to look at those pictures, were you leaning over his shoulder? Did you leave the room? What did you do?
No, I stepped back. A lot of times I just turn my back, and I did step back. I remember.
Okay. All right. Mr. Shepard, do you have questions for Detective Churchill?
Yes, just about how long did it take Mr. Jackson to make a selection?
It was fairly quick. I would say within a minute, maybe less than that, maybe 30 seconds, half a minute.
Was there any indication as to the level of certainty by Mr. Jackson?
He originally said, when we spoke, he didn't want to sign it because he didn't know who it was. And then later on in the conversation, as we spoke and talked, he said, man, that's him. That's him. That's it. He's the one that did it.
All I have.
Mr. Abate, anything else?
No, Your Honor.
1 second. Detective Churchill, did you have any more contact with Mr. Jackson after the photo identification process?
No, sir.
Okay. He never reached out to you later on to say either you can use my name or I take it back. I picked the wrong one.
No, sir.
Okay. All right. Appreciate your time.
Yes, sir. Thank you. I could be.
He'll let you know if you can go. You're welcome to step down. Yeah.
You certainly can. Thank you very much.
Mr. Abate, any other witnesses in connection with the motion to suppress the photo identification?
No, Your Honor.
Mr. Shepard, do you want to put up any evidence in connection with the motion to suppress identification?
No, Your Honor.
All right. Then the record is closed on that. Do you want to make any argument?
I'll stand on my motion.
Okay. Mr. Abate, anything?
No, I'll submit on the evidence, Your Honor.
All right, thank you both. Then let's talk about the phone records. Sounds like you've got an exhibit or two for that. I guess it's the search warrant for the phone records or warrants. I have 2 dates for some reason written down in connection with when I made notes when we were together in August. I have one of the things we're going to cover in connection with Mr. Shepard's motions on behalf of Mr. O'Neill. It was suppress items / cell phone. And there was a July 13th, 2021 date and a February 24th, 2022. I now remember that's the second date is when Mr. O'Neill was arrested. So I don't know if anything was seized from him then. I don't know the significance of the July 13, 2021 date. I don't know when you got the phone records.
I think that's the date on the warrant.
For the phone records. Okay, so that would cover phone records. The cell phone or phones you're trying to crack, that would have been obtained from Mr. O'Neill when he was arrested?
That's correct, Your Honor.
Okay, so that's the second date. So we've got phone records and then we've got phone.
Yes, Judge.
And he has the warrant right there, so I'm sure he can confirm it's July 13. That's what I have on my notes. Yeah, let me see it real quick. I think it would say it on it. That is correct, July 13th.
Okay.
No objection to the admission.
Okay. What number did we give that?
So it is State Exhibit 3, Your Honor.
Okay.
And then 3 and 3A. And I'm doing 3A because when the clerk's office certifies, it gives you a certified copy of the warrant. They do it front and back. So for easy reading purposes, I made a copy of the exact same warrant, just without front and back, so you could have it either way.
Okay.
So it's State Exhibit 3, 3A.
All right. And is that it sounds like this is the evidence you're going to rely on for the motion to suppress phone records.
That is correct, Your Honor.
Okay. Any evidence you want to put in, Mr. Shepard?
No, Your Honor.
Okay. Are you relying on the four corners of the affidavit or is there argument you want to make?
Just that within the four corners of the affidavit, there is not sufficient probable cause to warrant the issuance of the search warrant.
Got it. I will take that under advisement.
I think we're done.
I think that's it. I have this case down for final plea on the 9th of January. And then this case is on the February trial calendar. I would love if we can keep those dates. Mr. Abate is not the variable. It'll be you, of course. Mr. Shepard, I know you've got things going on early next year, but hopefully those two dates you can protect. I mean, final plea is not a big time commitment.
What was the final plea date?
The 9th of January.
I'll probably be on trial with Judge McAfee.
Okay. Well, if you know this is a case that's working out, we'll want to figure out a way to get you in here some. But if you know similarly, if the state's offer is life without parole and that's not going to work it out, we don't need to waive your client's final plea rights. We might just move, keep the case on the trial calendar, but preserve your client's final plea rights. But we don't need to sort that out quite yet. I don't know that you've got an offer. You and Mr. Abate we'll talk about it again before that final plea date. But if you are stuck in front of Judge McAfee, I don't want to change the trial date. We would just probably preserve your client's final plea rights and move it along.
Yes.
That work for you?
Yes.
Okay. All right. Anything else, Mr. Shepard, on behalf of Mr. O'Neill?
No, but I do have an unrelated matter.
Okay, we'll get to that in a minute and doesn't need to be on the record. Mr. Abate, anything else on behalf of the state?
Other than I'll continue to attempt to try to get a copy of Mr. Jackson's medical records. We've requested them, but it's always interesting with Grady how quickly and expeditiously they get them to us. So
Okay.
I will keep pressing to see if his blood was tested as a result of the treatment that he received that night.
Were you planning on calling any medical professionals as witnesses at trial? And I know there's an aggravated battery charge.
I was, Your Honor, and I had gotten the names of the physicians and the surgeons that worked on Mr. Jackson from his family members.
Okay, independent of the medical records.
Correct, Your Honor.
Okay, if you need an order, if you think an order would somehow pry those records out, you are much more experienced in trying to get things from Grady. But I'm happy to enter an order because that would get the records to Mr. Shepard too.
Thank you, Judge.
All right. Then I think that's it. We can go off the record. Thank you, Ms. Rivers. Mr. Shepard will be reaching out to you. Mr. Shepard, oh, and do you need Mr. O'Neill to stay up? You can talk to him in a minute, or can he go back?
I can talk to him for just a minute, but I've still got Douglas County. I started in Gwinnett, went to Cobb, now I'm here, and I still got to get to Douglas.
Okay, well, we'll keep him up for 2 seconds. You tell me what you want to tell me about something else, and then you can have a few words with Mr. O'Neill.
Be like 2 seconds for real. If I leave right now, I can still make Douglas County before
Okay.
traffic.
All right.
That's too bad. I had a conversation with Ms. Nelson the other day about specially setting the Reynolds case for the 22nd. I told her that there was a judge in Gwinnett County who was wanting to put me out to trial on that same day. Has that judge contacted y'all?
No, but I entered the order.
I saw.
Yeah. Is
So
the Gwinnett case older?
No.
Oh.
But the weird hiccup is the co-defendant filed a speedy. I didn't file a speedy. So they're wanting to try my client first because they've been severed. And I don't know. I'm going to be trying a case on January 22, whether it's
Here or Gwinnett. Who's the judge?
Timothy Hamill. He's the chief judge out there. He's super nice.
Yep. I'm happy to talk to him, but the scenario you described, the DA's office is going to have to come up with a different plan up there. That wouldn't get you from here. I don't want you stuck in the middle. And so if you start getting pressure from Judge Hamill, let me know. But the way that conflict gets resolved is pretty clear.
All the pressure is coming from the DA assigned to the case.
Okay.
Not from Judge Hamill.
Yeah.
He's
Well,
super nice.
That person's not in charge. So,
maybe someone could explain that to her. She sure does like bossing me around. But listen, Your Honor, I'm going to be trying a case.
Yep.
And you know darn good and well, when you've tried as many cases as you have and I have, it doesn't matter where you are. You know,
other than it'd be good to know in advance where it is you need to be. And that's what that special setting order was meant to do. And you have many cases. I would be disappointed and surprised if it was one older than Mr. Reynolds's case.
No.
So I think we got you. But I'm happy if it starts getting messy, let me know and I'll reach out to Judge Hamill. But if it's at the DA level, they need to understand how conflict rules work.
I thank you for that. And the other problem is that case is in the media. It's the hitman for hire case.
Oh.
It's all over the TV.
Oh, so I see why they would want to sequence it a certain way.
They're trying to convict my client and then pressure him to testify against the person who hired him.
Right.
It's always a pleasure. We sure knocked that out quick.
I appreciate the efficiency. So have a quick word with Mr. O'Neill, then you can make it on to Douglas County.
Thank you for your time today, Your Honor.
Sure.
Good day.
Were you all here for a case? Oh, hey, Mr. Logan. We're all waiting for Mr. App.
7F.
Okay.
7F with Judge Cox.
So I'll have my staff reach out to Judge Cox's staff to see their forecast as to when Mr. App, he is super in demand because YSL has taken a pause. And so we knew he'd be available and we wanted to lock this one in for the final plea conversation. I'm going to go back in my office, but just right across the hall. I'll come right back out here when we hear that Mr. Apt is coming. Or if I get word that, hey, he's going to be in there till 5, you should go and we'll just do this again. Because I don't mean for you to wait around too long, but it'd be great to get closure on this if we can. Let me ask, go back to the screen here. Hey, Ms. Clark, how are you?
Hi, Your Honor.
2 things. One, did you have a chance to talk with Mr. Apt or at least get him an offer before, this morning so that he's not going to come in here and say, I'd love to do a final plea, but I just got an offer from the state.
Oh, yes, Your Honor. I have provided, we have not had a chance to talk about this case, but I did submit an offer to, I filed one, a sentencing recommendation, and I submitted it to Attorney Apt by email as well, about 3 weeks ago.
Oh, okay. That's ample time. So then we just need to get Mr. Apt in here. I'm going to go back in my office and I'll see what I hear from my staff and I'll let you guys know. We're not going to forget about you. But stay here. Don't go to 7F. It'll be one of those things like where you cross and then Mr. Apt's in here and you're not. So don't go anywhere. We'll get him in here if we can. And if we can't, then we'll have to pick another day. Although we know one day that'll work, which is the 16th, because Mr. Harvey is available then. Ms. Nelson says she's reached out to Judge Cox's team. That is her polite way of saying they ain't calling her back. But we'll see what we can learn. And we'll call it at 3. If we don't have him here by 3, you should go. No minus points. You were here. And no minus points for your lawyer. He got double booked. And we'll see what we can do. So sit tight for about a half hour, a little less than a half hour. I'll come out before then if I learn definitively he can't make it or that he's on his way. All right? Thanks. You can stick around too? Great. All right. All right, Ms. Clark, if you, I don't know what your schedule is. I got an email that you wanted to chat. If you want to come by now is an okay time.
Okay, thank you.
Sure. let me get us.
Has your guy who pled me offer? He did.
Well, I think Dion, as part of his sentence, like his plea, he has to testify truthfully.
Okay.
I think both things, I think the answer is yes to both those things.
Okay, all right.
All right, so let's get on the record. Ms. Rivers, can you hear us?
Yes, I can.
Great. We're going to handle the final plea for Mr. Logan. Mr. Logan, come on up, please. This is 22 SC 185-229. And it's State versus Keandre Logan. Mr. Logan is here. His lawyer, Mr. Apt, is here. And we just need to get a few things on the record. Ms. Clark, if Mr. Logan wanted to enter a plea today, what is it the state would recommend? And if it involves charge reductions, let me know that as well so that I can make sure Mr. Logan and I are connecting on this.
So Your Honor, I made an offer that was different from what Mr. Apt just told me, that 88 Peoples had made him an offer of 10, serve 5.
And was your offer a more favorable or a less favorable offer?
Less favorable.
Oh, okay.
It's going up.
Well, but then we'll need to make sure. Ms. Clark was helping me understand that the handoff from Mr. Peoples to Ms. Clark, not always did all the information make it across. And so if that was an offer Mr. Peoples intended to keep open, he'll tell Ms. Clark and she'll honor that. That's the way we've handled this all along. Let's assume for now that it was the 10, because if Mr. Logan's going to say no to either at this point, we don't need to struggle about how to reconcile the two. We do need to eventually, if we're going to go to trial and you're looking at armed robbery, mandatory minimum 10 years in prison, then he's going to want to think about some of these other parolable options. It just may not be what he wants to do today. But I didn't mean to close you out, Ms. Clark. Do you want to get on the record Mr. Peoples' offer or yours, or how do you want to handle that?
Because I have not confirmed that offer, Your Honor, I would want to wait.
Okay, well, let me ask Mr. Apt, was your client inclined to, at this point, accept any offer that involved a custodial sentence?
I don't think we're going to be able to plead the case out today.
Okay. Well, but it's two different things. Well, but I guess they're tightly connected. If it's not going to work out today, Mr. Logan just needs to understand what that means in terms of his final plea rights.
Yeah. So I need a few minutes to confer with Mr. Logan, Your Honor. I apologize, and I apologize for my delay.
That's okay.
In being here, but I need just a couple minutes to confer with him. I do have in my file, which is not with me. I apologize. It's in the parking deck. But there was an offer made in writing, and I believe the offer by Mr. Peoples was 10 to serve 5 on armed robbery. So that would be a non-parolable sentence. But I have to confirm that, but I have it in writing somewhere in the file.
Okay. I mean, whatever it is, you've got it in writing. It wouldn't be hard to extract from Mr. Peoples, sent emails, et cetera.
Correct.
And Mr. Peoples may have said in that's my offer, but I'm leaving this division, and then there'll be a new sheriff in town, and she may have a different offer. So what I need to sort out in the next few minutes is whether Mr. Logan wants this case to move to a trial calendar. It doesn't mean that he's going to have a trial, but it means that we're not working it out today. And Mr. Logan would be free to enter a plea in the future. But if he does, unlike today, he could not withdraw that plea if the sentence that I imposed was greater. So let me just give you a specific example. Let's say that Ms. Clark says, all right, you know what, Mr. Peoples effectively bound the DA's office with this offer. So your offer is 10 years to serve 5 years with a balance on probation. And you were to say, all right, I want to go forward with that. And I heard all the facts and circumstances, learned more about you, and said, no, you know what, you're going to do 10 years, and I sentence you to 10 years. You'd be able to say, I'm sorry, Judge, I was willing to take the 5. I didn't like it, but I was willing to take the 5. You gave me 10. No, thank you. And you could step back from it. We call it withdrawing your plea. You'd be free to do that up through today. After today, you can still enter a plea, whatever it is you all work out. The only thing that changes is that you don't get to withdraw your plea if the sentence I impose is more severe than what Mr. Apt asks for. So if we fast forward, it's the day before trial is going to start, and you tell Mr. Apt, I don't want to go to trial. It's not going to go well, and I'm looking at a mandatory minimum 10 years. The state's offered me 7. 7 is better than 10. I want to do that, and you could take it. But if I gave you 8, that's 1 more than 7. You're stuck with that 8. Does that make sense?
Yes, sir.
Okay. Understanding these things, is it your desire, Mr. Logan, to enter a plea today, whether it's to the 5 years or something a little bit more from Ms. Clark, or is it your desire to have your case moved to a trial calendar whenever we can get Mr. Apt on trial, and maybe you work the case out, but at least you get a trial?
No, I don't want to take a plea today.
Okay, then that's what we'll do. Let me see if we have aspirationally put this on a trial calendar. I'm pulling it up if Odyssey cooperates. I guess you could do a trial every Friday. You could come in. We just have the jury show up every Friday.
If Judge Glanville will give us Fridays off. So far, I don't know that going forward we're having every Friday off.
No, Mr. Harvey was here earlier virtually and said the same thing. I said, don't you have Fridays in the new year? He said, nope, not necessarily. Just the week of MLK birthday.
We could do a Saturday, Sunday trial.
There you go. Enjoy that. Let me know how that goes. Well, it's not pulling up on Odyssey. Oh, here it comes. You're currently on our April trial calendar. We intentionally, that may seem far away, but you're on bond, so no problem there. But we knew that Mr. Apt was likely to be stuck in the YSL for at least the first few months, and we have to bump that perhaps, but maybe by then it will have cleared up a bit. So you're on the April trial calendar. Between now and then, you need to comply with the conditions of your bond. You'd be in touch with Mr. Apt, and if you all decide, hey, we want to sort this out, we can always bring everyone in to do that. But otherwise, we'll move forward. And just so you know, your trial would be of you alone right now. Mr. Burkott Dukes in the wind, don't know where he is. There's a warrant for him. So when he runs a stop sign, that'll pick him up, and then he will stay in custody until his trial. And then the other co-defendant, Mr. Gruyan, has entered a plea. So he's resolved his part of this. That's where we are. Mr. Apt, anything else? You feel like you've got the discovery in the case?
There are a couple items that we are missing, but I will follow up with the state, and I don't think we need the court's intervention with that, because
they're not confessions or something like that.
I mean, there are reasonably important things. There's some video evidence. There is a videotaped, I wouldn't call it a confession, but an admission by one of the co-defendants. And but I'm certain we can get that from the state. I don't think we need the court to weigh in. I think if I work with the state, we'll get it.
Do, and you know what to do if you can't get it, and then you reach out, and then we make you get it.
And I also think that there's a good possibility this case could get resolved, before it goes to trial.
Okay, excellent. Well, Mr. Logan, I will not see you before the holidays. Be safe. Stay out of trouble. Don't want to lose your bond. Mr. Apt, same to you, although you don't have a bond. And Ms. Clark, thank you for your work on the case. Okay? All right.
Your Honor.
See you guys.
Judge, happy holidays. Stay well.
You too.
Okay, so.
Ms. Jackson, Ms. Tucson, thank you all. We are done. Our 3 o'clock, it's now after 3, but it ended up not happening. So I will see you guys tomorrow.
Thank you, Judge. Have a great one.
All right, thank you.
Bye-bye.